This episode of Southeast Iowa Today is brought to you by Greiner Auto Body of Washington, Iowa, using state-of-the-art techniques and decades of experience to get your car back on the road after an accident. Car Doctor of Washington, Iowa. No matter who Frankensteined it, they can fix it, clean it, and customize it. McDonald Boneyard of Keota, Iowa, for all your farm equipment and auto recycling needs. For great food, it's your choice. Your Choice Family Restaurant of Wayland, Iowa. Open Tuesday through Sunday. Come to our cruise-ins this summer on the second Tuesday of the month, June through September. Girling Repair of Winfield, Iowa. If your mower is dead, call Fred, your Husqvarna, Aaron's, and Gravely dealer. Fred also fixes and sells snowblowers. B&B Propane and the family of Jet Stops. Dutch Market and Coffee Talk of Washington, Iowa. Dutch Market can handle all of your grocery needs. They even have a conference room you can use for free. Coffee Talk's drive-thru is open and ready to serve you coffee, energy drinks, sandwiches, baked goods, and ice cream. They all present you the award-winning Southeast Iowa Today. Here's the author of Christie's Journey, The Beat Goes On, and your host, John Bain.
Thank you, announcer Cody Roy of NewEnglandDukes.com for your golden pipes and wonderful introduction. Ron Greiner and the Highland School District had their day in court today on Tuesday, April 15th, 2025. It's a summary judgment. I believe I said that right. Anyway, I'm going to take you inside. It's long. It goes over an hour, folks, but the school district says it's all about they had enough votes, whether or not some were legal or not, to push their bond issue through. And Ron Greiner's point is they had 96 votes that were illegal and wrong, and there needs to be election integrity in this country. So let's go check it out.
Good morning, everybody. This is Washington County case number CVEQ 007372. Ronald Greiner and Marcus Fedler et al. Concerning the Highland School District. The record reflects that the petition in this matter was filed February 5th, 2025. On March 11, 2025, the district filed a motion for summary judgment that was timely resisted by the petitioners. Petitioners filed a cross motion for summary judgment, timely resisted by the district. And this is the date and time set for hearing on the motions for summary judgment. For the petitioners is Attorney Sasha Fink. For the district, Attorney Andrew Tice. Mr. Tice, you filed the first motion for summary judgment, so I'll let you proceed.
Thank you, Your Honor. So on behalf of the Highland Community School District, we're seeking summary judgment and dismissal of this election contest appeal. The school district, of course, educates community's children from pre-K through 12th grade. In order to do so, they require facilities. And last year, the district received a petition that had been signed by nearly 35% of the eligible electors within the district, requesting the issuance of bonds in order to improve their facilities. That petition went to the board, and the board voted to approve putting a public measure up for election on November 5, 2024, which is what happened. The vote went forward in 3 different counties, and Your Honor, that's because the district crosses some lines. So the vote occurred in Washington County, Johnson County, and Louisa County. And in order to pass, it required a supermajority of 60% of the votes cast. Upon conclusion of the election, there were, somewhat interestingly, 2,222 votes, a number that fortunately makes it a little easy to remember. Of those total votes, 1,361 were yes, 861 were no. So the vote passed with 61.3% of the vote. Your Honor, the accuracy of these notes are not and have not been disputed. The canvassers and auditor both found that the public measure had passed. The petitioners here have contested these election results based on an irregularity at one of the 5 precincts within Washington County. Specifically, the evidence indicates that at the Ainsworth precinct, election officials had given ballots with the district's public measure on it to all of the voters for a portion of the day. It should have only gone to voters that were registered within the district. That was corrected, I understand, midway through the day. The school district is not disputing the fact that improper ballots were distributed for a time within the Ainsworth precinct. What the school district maintains is that that furnishing of improper ballots under these circumstances doesn't change the result of the election, so therefore the election contest fails. Fortunately, this court is not left to guess how to handle a circumstance like this because the legislature has already provided direction. Specifically, Your Honor, at Iowa Code 57.4, Iowa law indicates that when election officials at a precinct have distributed improper ballots, that impropriety is not sufficient to change the election results if we throw out those votes from the particular precinct. So in this case, if we look at the Ainsworth precinct, the only precinct at issue here, and if we were to reject those votes as Code 57.4 says to do, the public measure still passes, this time with an even higher supermajority of 64.9% of the vote. There would be 1,115 yes votes, 605 no votes, and again, Your Honor, these numbers are not the subject of dispute. So we believe that consequently the election result cannot be set aside because the rejection of votes in the one precinct where misconduct occurred doesn't change the result. The contest court, we believe, was correct, and this court should affirm and dismiss the petition. So underpinning our motion, Your Honor, there's two chapters that set forth how to handle these types of election contests. They're chapters 57 and 62. Iowa Code 62.5 requires contestants, like the petitioners here, to file a statement of intent to contest the election. Our petitioners here did that. They filed a petition that's included within, I believe, both parties' appendix. In the district's appendix, it's appendix item 9, page 24. That petition sets forth the only grounds in which the petitioners have challenged this election, and it remains that way today. They haven't changed to add any other form of impropriety to counting or anything like that. It's simply the distribution of ballots at the Ainsworth precinct. Now the district contends the viable ground, the only viable ground to try to challenge an election under these types of circumstances is within 57.1 subsection 2A. You'll find, Your Honor, at 57.1 the various grounds that election contestants can use to challenge an election's results. 57.1 subsection 2A provides that when there's been misconduct, fraud, or corruption on the part of any election official or of any board of canvassers of sufficient magnitude to change the result of the election, that would be the challenge we believe that would apply here. Now, nobody is making any allegation of fraud or corruption. Instead, the district submits that what happened here would be properly characterized as misconduct. Your Honor, if you look at Iowa election law, it does define misconduct, not within chapter 57 or 62, but under chapter 39A. Chapter 39A is part of the Election Misconduct and Penalties Act. And it's within that statute that it lists off a slew, many different forms of misconduct that are criminal in nature, first through fourth degree. If we look at third degree election misconduct, it defines one form of misconduct as, quote, furnishing a voter with a ballot other than the proper ballot to be used at an election, end quote. Now, that's a long citation, Your Honor. It's chapter 39A.4, subsection 1B4. That's what I just read from. While nobody is accusing the precinct officials at the Ainsworth district of doing this intentionally or of committing a crime, the term misconduct applies the same between 39A and 57 or 62. Now it's 57.4 that we believe is the operative code section. It's referenced within the contest court's memorandum of decision, though it doesn't indicate that that was the basis for the decision. It's 57.4 that reads, When the misconduct, fraud, or corruption complained of is on the part of a precinct elected officials in a precinct, it shall not be held sufficient to set aside the election unless the rejection of the vote of that precinct would change the result as to that office. So that's the instruction from the legislature for this court on how to handle this particular situation, requiring a look to see what happens if we reject those Ainsworth precinct votes. And I would note, Your Honor, that statute has been considered before, or a very similar provision in Brooks v. Fay more than 100 years ago, where the court affirmed the legislature's power to declare a precinct's vote be rejected due to misconduct at that precinct. In essence, the Brooks court, Your Honor, held that the legislature had the prerogative to say one way or the other whether we're going to reject it or not. But that was what the legislature chose to do. So there's no dispute here that this public measure passed with 61.3% of the vote, and if we reject the Ainsworth precinct, it passes by even more, 64.9% of the vote. There's no dispute over these results. There's no dispute over what happened at the Ainsworth precinct. For those reasons, we think the contest court was correct and that this appeal should be rejected. The response, Your Honor, of course, is always another side of the coin. The petitioners contend that 57.4 does not apply because this is not misconduct. The argument there is that misconduct requires intentionality, and we don't believe that there's merit to that argument. We've set forth the various reasons or what we perceive to be flaws in that argument in our reply brief, which should be before the court. In essence, we've cited the court to dictionary definitions and a prior case law that says misconduct in and of itself can be intentional or unintentional. In fact, we even cited the court to a Drake Law Review that has an entire chapter that is entitled Intentional versus Unintentional Misconduct. And then we go to, of course, the Election Misconduct and Penalties Act, Chapter 39A. The petitioners contend, well, that shows it must be intentional. And it's true, Your Honor, that under 39A, if you're going to charge somebody with a crime, it does need to be intentional. But it's not because of the legislature's use of the word misconduct. It's because that statute adds to misconduct and says it needs to be willfully committed. That's the intentionality component to it. We're not arguing that there was any willful commission of misconduct here. This is the unintentional misconduct that would be covered under 57.1 and 57.4. The petitioner also refers to two cases, I think, and I would agree with the petitioner's counsel that there is scant authority that would apply these particular statutes. And so even in petitioner's brief, they referenced the Brooks decision I was mentioning to you earlier, as well as the Fiedenheft versus Frick decision, both somewhat dated 1928, 1943. The district would submit that both those cases really support the district's position. The Brooks case involved the court finding misconduct when election officials, I believe they used to call them judges, that would preside at the polling place, were soliciting a handful of votes. There's nothing in that Brooks case that indicates the court went into intentionality or motive, simply that they had solicited votes. We don't know from the reading of the case if it was an unintentional violation of the law. But it's even more clear in the more recent decision, the Wiedenheft decision. There, the court found that there was absolutely no evidence of corruption and stated the only evidence of misconduct was when the officials opened 12 absentee ballots before closure of the polls. Something I think that quite easily could be an unintentional violation, but yet the court was characterizing as misconduct. Again, with no reference to the motives that might have been behind the involved actor's conduct there. So we believe that that even more shows misconduct can be either intentional or unintentional. Your Honor, we also believe the statute itself, if it was interpreted as petitioners contend, would make the word misconduct superfluous. As I was reading to you, 57.1 and 57.4 both reference the three terms, misconduct, fraud, and corruption. If the court were to interpret the word misconduct as only including intentional acts, it would make it superfluous because fraud and corruption would already cover those acts. Misconduct is more readily interpreted as including the unintentional acts within that statute. And then finally, there's considering the result, that if the petitioner's contention was correct, that misconduct does not apply to unintentional acts, but only intentional, then I think the consequence here would be backwards. We would have 57.4 allowing election results to stand in the face of outright fraud, corruption, and intentional acts of misconduct. But we're not going to allow the results to stand if that was a mistake, unintentional misconduct. And that's got it backwards. I think that everybody would intuitively say that the intentional act should have a harsher consequence rather than an unintentional mistake. So rather than go down the path that we believe would have been the appropriate path of 57.12A and 57.4 for misconduct, petitioners have framed their challenge as an illegal votes challenge. That's a different subsection for grounds. That's 57.12E. And in that code, it says that there can be an election contest when illegal votes have been received or illegal votes rejected at the polls sufficient to change the results of the election. We do not believe that the petitioners can viably present that kind of a challenge for two reasons. One, they're barred from doing so, and two, they can't make their evidentiary burden of proof. On the barred component, Your Honor, if you're going to make an illegal votes challenge, Iowa law makes it mandatory that the petitioner or contestant submit a statement that sets forth the individual names of each person casting the illegal vote, as well as the precinct where they should have been voting. And this is at code 62.5 subsection 2E. It states that a statement setting forth the names of the persons who are alleged to have voted illegally or whose votes were rejected in the precinct where they were voted or offered to vote must be submitted. The petitioners admit they did not do that. In fact, I think the petitioners have, if I'm reading through their motion papers, will acknowledge they can't do that. They won't be able to do that. Instead, they argue it wasn't necessary. The district would maintain it's not up to contestants to decide which parts of the code are necessary. It's the legislature, and that's also referencing the Brooks case that makes that point very clear. But we also know just from reading through that statute, we know what the word shall means. Shall is mandatory. Shall is not discretionary, and it says in the statute a statement shall be included. We believe, Your Honor, and this is mentioned in the briefing, that this is a strict compliance portion. It's jurisdictional. I understand that the petitioners will disagree with that and believe it's substantial compliance only. There's no case authority directly on point, because what we're arguing as jurisdictional is the statement required for this particular kind of challenge for illegal votes. And I would be clear, Your Honor, that while we have all these different ways in which elections can be contested, the legislature's requirement for a statement that sets forth individual names applies only to that subsection 2E challenge for election votes. It's very important that we have the names of each person that a contestant believes illegally voted. But we believe that's a strict compliance requirement that they've failed to meet. But quite frankly, under either strict or substantial, the complete absence of a statement, we think they failed to meet. Now, when you get to whether the petitioners can actually establish illegal votes were cast here, we also don't think that there's any way that they can meet their evidentiary burden of proof, because they will have to actually show that these individuals, for which they have no names to provide, illegally cast votes. Now, the petitioner's argument is, well, we have evidence that indicates ballots were handed out to people that might not have been registered in the district. But when you look through the case law, Your Honor, that's cited not just by the district, but also by the petitioners here, you'll see repeatedly, and I was actually quite proud of our courts and their prior rulings, how detailed and focused they are on each individual voter when there's an illegal votes challenge. The petitioners cite to Taylor versus the Independent Community School District of Earlham from 1917, Paulson versus Forest City Community School District in Winnebago from 1976, and Kinney versus Howard from 1907. Notably, all of those cases go into a very detailed assessment, mostly about residency of individual people that have been alleged to have voted in elections. And they go down the path of intent. I mean, sometimes a person was living in one spot, but then they were traveling to another. Where did they intend to reside at that particular moment? It is exceptionally detailed, and that's why the legislature requires individual names, and why you can't do it in a summary fashion and just kind of say, well, we think unnamed people received the wrong ballots. It's unique to the person. So nothing has been alleged here to say that any of the people that voted in the Ainsworth precinct were barred from voting non-citizen or felon or anything like that. There's nothing there that says any of these people were underage or lacked capacity, or that they had multiple residences or voted in different places. All that's been alleged is that these people that would have been legal voters showed up at their polling place and were handed a ballot that had an additional question for some that they shouldn't have answered. That's it. So to say that these are illegal votes, it's very different than all of the case law you'll see under that code section 2E, which is all about the individual. So that's why we think that the petitioners here can't meet their burden of proof under that code section. And for completeness, Your Honor, there was one other provision of the code that petitioners originally identified, but it's not part of any of the summary judgment papers. So it's not something that's been asserted to resist summary judgment or to seek it, but a subsection 2F challenge. So that's 57.1 2F, which is a provision to challenge election results when there's a perceived error in any board of canvassers in voting or in counting the votes or in declaring the result if the error would affect the result. There's no evidence here, Your Honor, of any counting errors or any declaration of the result that would affect this election. So we don't think that that's really a viable challenge or even one that's being maintained at present. Thank you, Your Honor. For all those reasons, the district would request summary judgment be issued dismissing the petition appeal before the court.
Thank you, Mr. Tice. Ms. Bain.
Thank you, Your Honor. So I will first address the district's motion for summary judgment, and as I understand from the briefing done as well as the arguments of the district's attorney, the sole grounds, there's two grounds that the district seeks summary judgment on this case. The first ground is the allegation that the petition to contest was ineffective or not substantial, or did not have substantial compliance with the statute. And then second, under Iowa Code 57, 1, subparagraph 2, subparagraph A, the allegations in the petition assert misconduct, and because disposal of the Ainsworth votes would not affect the ultimate result in a case, that the election should stand. So first, Your Honor, I'd like to point out that when the election laws were initially passed, they did not cover elections on public measures. And sometime in 1970, the legislature added public measures to the type of matter that could be contested under the election laws, and specifically the election contest laws. And so case law prior to that time frame provides general guidance on how election contests were handled, but don't necessarily specifically refer to any sort of school election. They were previously handled through a different mechanism, through filing for injunctions and stuff like that. So with that, and in addition, as counsel for the district indicated, the case law is very scant on interpretation of the election laws and various provisions thereof. So first, turning to the district's contention that the petition in and of itself is fails as a matter of law. While the district cites DeConing versus Nolima, and that case basically stands for the proposition that statutory provisions necessary to confer jurisdiction must be strictly complied with. But as the court said in Haas, as well as other case law that's cited in the brief, the content of the petition itself is not jurisdictional and has not been determined to be jurisdictional. So that is also supported by another subsection in chapter 62, which is section 6214, and that section specifically indicates that the statement of intent, so the petition that's filed to appeal, shall not be dismissed for want of form if the particular causes of contest are alleged with such certainty as will sufficiently advise the incumbent of the real grounds of the contest. So, and again, Your Honor, in this particular type of proceeding, the Weindenhoff versus Frick court indicated in that ruling that at this point we cannot refrain from pointing out the inadequate election contest laws found in chapter 47 and 52 of the code. These sections making the provisions relating to contesting elections of county officers applicable to contested elections for other officers or offices well illustrates the vice of a reference statute. The court went on to say, we can understand the dilemma of counsel for both parties when faced with the problem of fitting their issues into such inadequate statutory election contest machinery, and we commend them for the excellent presentation of the merits without burdensome formal objections. And so, Your Honor, the petitioners in this case presented with the issue that is undisputed, found themselves in a dilemma in looking at the various grounds set forth in chapter 57 to specifically identify which grounds their challenge neatly fit into, and it doesn't, because the type of issue here and the type of election irregularity doesn't neatly fit into any of the grounds. First, the district argues that since the petitioner's statement references 57.1 E and F instead of 57.12 E and F, that it should be dismissed because it's not strict compliance. Your Honor, I don't think anybody did not understand from the beginning what sections were being referenced in the petition. The petitioner cited to the right chapter, and there's only one subsection in chapter 57.1 that has an E and an F. So the petitioners assert that their statement in the petition to contest sufficiently alerted the district and everybody else involved of what grounds were being contested. Interestingly then, while the district on the one hand claims that the petition should be dismissed for not referencing subsection 2 of 57.1, the district argues that the petitioner's contest should be dismissed under a subsection of 57 that wasn't even referenced or pled in any regard in their petition. The petitioners indicate or assert in this matter that setting aside votes is not insignificant. It's the whole premise of the fact that they filed the petition was to protect the sanctity of an election. The district residents in the Ainsworth precinct have a fundamental interest in voting on a measure that ultimately results in taxation of their property. and only in limited circumstances does the statute allow for a group of otherwise legal votes to be completely disregarded. And that singular exception is found in Iowa Code 57.4 and only applies when there is misconduct, fraud, or coercion in a singular precinct. And so before I get into talking about the application of that, just generally, the petitioners have not alleged any sort of misconduct whatsoever by the election officials. And I think it's undisputed that it wasn't intentional. Both the district's briefing as well as the finding of the contest court had the understanding that the precinct officials did not know there were 2 ballots to begin with. And so they were just passing out one. And when it was brought to their attention, there were actually 2 ballots. Then they switched and started handing out 2 ballots. So the petitioners disagree that the allegation and the petitions make it clear that there's a substantive challenge under 57.12A. Unfortunately, misconduct is not defined in Chapter 57, but it is used in conjunction with the word fraud and corruption, and so that provision has to be read as a whole. The district initially in its motion suggested that the act of handing out the wrong ballot amounted to election misconduct and relied on the Election Misconduct and Penalties Act statute. Your Honor, that statute was enacted in 2002, and first and foremost, I don't see how a statute enacted in 70 years after the initial election laws provides a definition of misconduct of a statute that's been in existence that long. So secondly, the title of this statute or the act is Election Misconduct and Penalties Act. The entire act refers to election misconduct, and it's a penal statute. The stated purpose of this act is to, quote, identify actions which threaten the integrity of the election process and to impose significant sanctions upon persons who intentionally commit these acts. So, despite what the district argues, the legislature has declared that the purpose of the Election Misconduct and Sanctions Act is to punish people who intentionally commit election crimes. The district argues that the use of the word willfully in Iowa Code 39A.4 provides the intentional nature of the act or somehow modifies the word misconduct otherwise used in the statute. Again, I think that's clearly contrary to the stated purpose of the act. And willfulness, Your Honor, under Iowa law is not the same as misconduct. In fact, in a case cited by the district in their reply, State versus Meeks, The court explains that willfully means more than a voluntary or intentional act. It includes the idea of an act intentionally done with a wrongful purpose or with design to injure another, or one committed out of mere wantonness or lawlessness. So misconduct and willfulness do not necessarily go hand in hand, but you can't take the interpretation of misconduct a step farther, as the district would request the court to do, and eliminate the intentional nature of misconduct in and of itself. Next, the district refers to the use of the word misconduct in other general applications and cites to the Merriam-Webster dictionary and dictionary.com, and the definition cited by the district in the Merriam-Webster dictionary. It includes in the definition intentional wrongdoing and improper behavior. I think that supports the petitioners, not necessarily works against them. Additionally, in the dictionary.com definition cited in the reply brief, it includes a definition of improper or wrong behavior, unlawful behavior by an official. And again, Your Honor, I think that supports the petitioner's position instead of detracts from it. The district, in its reply, says the term misconduct by itself is commonly used more broadly than what the petitioners would ask the court to interpret it as. But again, in this case, the term misconduct is not used by itself. It's used in conjunctions with the term fraud and corruption, which clearly are both intentional acts. The Drake Law Review that was cited by the district in their reply brief and referenced today in argument refers to prosecutorial misconduct, which is a special subset of misconduct. Petitioners believe misconduct of the nature that is being referenced in 57.12a is similar to, for example, the definition of misconduct in labor law. In order to be disqualified for unemployment benefits, misconduct requires an intentional act or omission. And so the general nature of misconduct, generally used in carrying out one's duties, assumes that there's some intentional action on the part of the actor. As a petitioner set forth in their brief, there's only 2 cases that have interpreted misconduct that petitioners could find as it relates to the election laws, and that's Brooks versus Fay, as well as Winehoff versus Frick. Brooks versus Fay involved an allegation that one or more of the election judges of a particular precinct solicited votes in favor of a particular office. The court found that the solicitation of votes in favor of that particular office clearly constituted misconduct. The district in turn suggests, because the court did not undergo a discussion or analysis of the intent behind the solicitation, that intent intentional is not, part and parcel to misconduct. Your Honor, solicitation is an offense where the crime is the asking. The very concept of solicitation is intentional. For fun, I did a Westlaw search for, quote, unintentional solicitation, end quote, in the state of Iowa, and there were 0 results. And so I did the same search in all 50 states. And again, there were absolutely 0 results, because the idea is solicitation is by, in and of itself, an intentional act. So it makes sense why the court in Brooks had no discussion of the underlying intentional nature of the solicitation. Now, what the court did say is that the conduct of the judges complained of invites condemnation. I mean, that statement in and of itself suggests the court found their conduct reprehensible and clearly intentional. With respect to the second case, the Weidenheft versus Frick case, that was raised by the petitioners to point out that in some instances there are allegations of misconduct that don't rise to the level of the type of misconduct needed to set aside an election. In that case, the alleged misconduct was a judge from either party, or both parties, a Republican judge and a Democratic judge, opened some, I think 12 ballots before the polls closed, and that was contrary to the statute. In that regard, the court said the only evidence of misconduct was premature opening of the ballots, and this act was insufficient to throw out the votes of the entire precinct. The district suggests then that because there was no discussion of the underlying intent, that even unintentional violation of the law or some unintentional failure to follow the law constitutes misconduct under 57.12a. To the contrary, Your Honor, the case didn't have to go into any detail in deciding whether the misconduct was or was not of sufficient magnitude, because in that case, there were only 12 ballots opened early, and the court said those 12 votes were insufficient in number to affect the result of the election, and it didn't need to go into additional analysis. So again, the petitioners would disagree that the district's interpretation of the Weidenheft case is contrary to the petitioner's position. Next, the district argues that if the court were to adopt the petitioner's interpretation of the word misconduct and limit misconduct to only intentional acts, there would be, it would be super flawless to include also the words fraud and corruption. The district is essentially arguing that fraud, corruption, and misconduct are synonymous if the interpretation of misconduct requires intent. petitioners disagree. I think first and foremost, what is telling is in the statute, the words misconduct, fraud, and corruption. We clearly know what those mean. So then, where does misconduct fall into play? I think it makes a lot more sense that if the legislature intended that code provision to apply to non-intentional acts, they would have used the word negligence. The word negligence has been a staple of common law for years and has all the elements of having a duty, breaching the duty, that sort of thing. But essentially, the district is asking the court to interpret the word misconduct as essentially covering negligence. So, Your Honor, with respect to the district's motion for summary judgment, the petitioners have not alleged misconduct under 57(1)(2) subparagraph A. The conduct alleged, the irregularity that happened was an oversight, an unknowing omission, that does not rise to the culpability that 57(1)(2)A is intended to cover. And for that reason, 57.4, which discusses when a singular precinct is involved, that if the elimination of the entire vote would not change the result of the election, then the precinct's vote should be eliminated and election stand. In our resistance, Your Honor, and I won't regurgitate all the case law to you right now, but we cited multiple cases discussing this very issue of why, when there's been misconduct in a particular precinct, the votes of that precinct are set aside and the election stands. And that's essentially the theory is that if it's limited to the fraudulent conduct of the judges in one precinct, they shouldn't spoil the remaining votes of the other precinct, and they should be punished for their bad acts themselves. And again, Your Honor, that's not the case we have here. It's not intentional bad acts of the precinct officials in the Ainsworth precinct. And more importantly, I mean, to set aside the entire Ainsworth precinct is a very harsh result. If you take away the 96 ballots that should not have been cast, the Ainsworth precinct made up approximately 25% of the total votes. That's 1/4 of the vote. To tell 1/4 of the qualified valid voters that their vote is being disregarded because a mistake was made in passing out ballots is not the type of harsh result that 57.4 was intended to impose. Essentially, interpreting misconduct and this challenge as the district would request amounts to an unwarranted disenfranchisement of the qualified voters of the Ainsworth precinct. That also involves the disenfranchisement of a substantial number of absentee voters, which weren't even involved in this error that was made. To safeguard the purity of elections, Your Honor, the matter, we feel, must be sent back to the people and a new election be conducted so that it can be determined with certainty whether the bond has a popular vote. The elements of the content of a ballot is an essential function of the election. In case law, prior to contests of school public measures being added to 57 and 62, chapters 57 and 62, I mean, the court said in both Harney and Honahan that the general principle is that there may be a minor mistake with some sort of irregularity. However, if it's a major mistake with respect to specifically the contents of a ballot, that is fatal and the election cannot stand. So first and foremost, the petitioners believe that the district summary judgment motion should be denied on the grounds that the challenge by the petitioners falls under 57.1 subparagraph 2 subparagraph A. So if the court agrees with that, then the secondary challenge isn't necessary, which is whether or not the sufficiency of the alleged irregularity would result and would lead to a different result. And again, Your Honor, there's several cases that are cited by the petitioners in their resistance that refer to how that is determined. And so again, chapters 57 and 62 do not define sufficiency to change the result, but in reviewing Iowa case law, as well as cases in other states that have similar election laws, if the total number cast were all cast in favor of the declared winner, or in this case, approval of the public measure, and if those were taken away, if that winner and or approval of the public measure would not have the sufficient votes for passage or election, then it's sufficient to change the results. In this case, it's clear. Well, back up. So first of all, just to point out, I mean, in the appendix, the Canvas summary is included at petitioner's application, page 7, and it has kind of a breakdown of the different precincts in Washington County. That includes Ainsworth, Kelowna, Richmond, Riverside, and Ward. So one of the issues, or one of the contentions by the district is it's not known if or how the voters who were ineligible to vote on the public measure in fact voted. And so if you look at petitioner's appendix, page 7, it shows that on the day of the election, there were 26 undervotes from the total 385 votes at that precinct that day. Even if you were to subtract that number of 26 from the 96 total ballots, there would be 70 ineligible non-district resident ballots turned in that voted on the measure. So we know for a fact that at least 70 of the 96 ballots, if we were to assume all undervotes were from that group of people, then we know 70 non-district resident voters answered either yes or no. And 70, again, is more than 26, so it clearly was of a significant enough number to change the vote. So for all of those reasons, Your Honor, and for reasons that are more detailed in the written material submitted in the resistance, the petitioners would request that the district's motion for summary judgment be denied. With respect to the petitioner's cross motion for summary judgment, the petitioners contend that, I apologize, I'm getting sick and I'm struggling. Well, I'm trying to keep going through it. So the petitioners seek summary judgment under 57.12 subparagraph E, which states that there have been illegal votes have been received or legal votes rejected at the polls sufficient to change the results of the election. Here again, illegal votes is not defined in Chapter 57 or Chapter 62. However, we do have Iowa case law that provides some context. For example, in Taylor versus Independent School District, which is cited in the brief, the ultimate finding of the court is essentially that votes by non-resident voters were deemed to be illegal. In Paulson versus Forest City, again, another case cited in petitioner's brief, the court noted that in proceedings after election, so in contest proceedings, the contestants may show under section 57.1 that illegal votes have been received or legal votes rejected at polls sufficient to change the result. In that particular case, in Paulson, it was alleged that a group of college students were not qualified residents and should not have been allowed to vote on the particular school measure or school district measure. However, ultimately, it was held that the students were in fact qualified residents, and so the ultimate question never got addressed. But the point is, the court phrased it as a challenge or described it as a challenge to the receipt of illegal votes. So, I mean, extrapolating that explanation by the court, if someone who is not qualified by residents to vote on a public school measure, then ultimately the vote cast for the public school measure is illegal. And similarly, even earlier case law, Your Honor, in Kenny versus Howard, the court referred to a vote by a non-resident of the township as an illegal vote. And so the votes of the 96, the votes of the 96 non-district residents would fall in line with what Iowa courts have previously held to be illegal votes. The district, in turn, then argues that the petitioner's cause under subsection E cannot go forward because the names of the 96 non-district resident voters was not included in the statement of intent. First and foremost, Your Honor, with respect to the requirement that the names and other identifying information be included, I think that requirement has to be read in conjunction with Iowa Code 62.14, which again states that the statement shall not be dismissed for want of form if the particular cause is understood. Here, in this case, although we don't know the names or how they voted, the fact that the names were not included in the statement of intent, Your Honor, our position is it wasn't necessary. The district and the contest court and you know, the attorneys in this case have all asserted, acknowledged, and agreed that 96 ballots with the public measure were handed out to non-district resident voters. What their names are is irrelevant. It's an entire class of people that were given and filled out the wrong ballot. While it's not per se a stipulation, the district's briefing itself acknowledges this fact. So our position is this is a stipulated fact that this happened, and it's the act of the ballot being handed out that is the challenge to regularity, not the names of the individuals who it was given to. And it makes sense in this case, given the nature of the underlying irregularity, which is improper ballot being supplied to non-resident voters, to not require the names and addresses in order for the merits of the petitioner's challenge to be heard. The names of the 96 non-resident voters is not available to the petitioners. They have no way to access that information. And so essentially, the district is requiring the petitioners to do something that they have absolutely no ability to do. And so I don't think the law and the election laws in particular are designed to forego or prohibit an otherwise completely rational and justifiable challenge to an election because the petitioners don't have the evidence available. It's unheard of in other areas of the law that a petitioner would be prohibited from asserting a case or bringing a case because they didn't have the information requested at time that the petition was filed. Furthermore, I mean, I think even as the district contends, all the cases that are referenced in the briefing and that have involved challenges to illegal voters, the issue in each of those cases was the individual qualifications of a particular voter. Had nothing to do with the ballot that was given out. And so when the underlying challenge is this voter qualified to vote on this ballot, not did this voter get the correct ballot, then it makes sense to require the names and information of those votes being challenged so that that person's information can be reviewed, assessed, and addressed. And that's what all the cases involving that type of challenge undertakes and does. And so that it serves a purpose in that particular illegal votes case to have the information of each of the voters. Whereas in this case, the identity of the voters has already been established. There is a document that is in both parties' appendix from the auditor's office indicating specifically the number of ballots with the public measure that was given to non-resident voters. It's 96, we know that. Again, what would having the names of those 96 voters accomplish? When we're talking about being able to move forward to determine the merits of a challenge, the petitioners contend that the requirement of listing the names in this particular case is not a necessary prerequisite such that their petition should be dismissed for failing to list out those names. And again, as stated by the Iowa court, even back as far as 1936, the court stated that the sufficiency of the statement filed is not a jurisdictional question and strict compliance is not required. The real purpose of the filing of the statement is to make a record, of record the objections and complaints that the contestants have, and to make a showing of why the incumbent is not entitled to hold the office to which he or she has been declared. So for that reason, Your Honor, we would request that the court interpret Iowa Code 62.5, which requires the names of the particular voters to be read in conjunction with Iowa Code 62.14 that indicates statement of intent should not be dismissed for want of form. The statement of intent clearly identifies the information of the then known issue, which was flushed out in the contest hearing and memorialized in the contest court's decision. So again, clearly all the information needed to decide the merits was provided in the petition, and for that reason the petition should not be summarily dismissed as the district requests. Then the other issue, the final issue, is the district's contention that irrespective of whether the petitioners met the pleading requirements, the district contends that the petitioners have not submitted undisputed evidence that the illegal votes received were sufficient to change the results. And again, I think it's a similar issue to the evaluation under 57.4. They use a little bit different wording, but the concept is the same. And the case law that's cited in our brief supports our interpretation, Your Honor. For example, in Warrington versus Community School District of Ansgar, the court explained if the irregularity raises doubt as to how the election would have resulted if it did not occur, then it's deemed to be fatal and will warrant rejection unless it's possible to separate the legal votes from the illegal votes. And Your Honor, I think it's undisputed in this case, we're unable to separate the illegal votes from the legal votes, which would warrant a re-election. Again, in another case, the Coggeshall case, also cited in the brief, most telling to the case at hand, the court explained the general principle is that sometimes there are issues within elections, and though acting in good faith, the election officer commits errors which will violate the election. If they have done something by which illegal votes were admitted and a number sufficient to change or render the doubtful the results, then the election is void unless there is proof upon which the poll can be purged of the illegal votes and the true results shown. And again, Your Honor, we're unable to do that because the plaintiffs, the petitioners don't have that information. The illegal votes were commingled with the legal votes, and it's impossible to separate them after the fact. And then in the Honahan case, Your Honor, also cited, in that case, the irregularities complained of were twofold. The first was the particular ballot instructed the voter to mark an X for the particular issue, and that deviated from the statute. The second allegation of irregularity was that 9 voters lived in an area later annexed without putting much discussion into whether they had a valid claim of later being annexed. The court said, as a practical matter, the number of votes could not have changed the result, even if they were all negative. So, if you read Iowa case law together with the statutory language, it's clear that Iowa courts have generally held and are of the opinion that when challenging an election based on illegal votes received, if the number of votes that were illegally received exceed the margin of victory of the winner or the winning measure, then a new election is required. And again, Your Honor, without belaboring the issues, again, it's briefed in the briefs. The premise, dating back to the 60s in Harney, as stated in Harney, in school elections, the general rules that mirror irregularities in the conduct of the school election or minor defects in the form of a ballot do not affect the result of the election, but defects in matters of substance are fatal. Our contention, Your Honor, in this case, that ballot containing a public measure given to non-district residents who are not qualified or eligible to vote on the matter is not a minor defect in form. It's a very substantial defect of the ballot and requires, and was of sufficient number to change the result and therefore requires that the election result be voided and the matter be sent back to the people for a legal and valid vote. So in that respect, Your Honor, the petitioners would request that the court enter judgment in their favor on their cross motion for summary judgment under Iowa Code 57.12E, finding that the petitioners have essentially successfully proven that there were illegal votes received in a number sufficient to change the result, warranting or rendering the election void. Thank you, Your Honor.
Thank you. Ms. Green, you can see that the subsection F challenge, the counting challenge, that I can enter summary judgment on that. Meaning that if there were illegal votes cast, they were accurately counted. What's your position on the subsection F?
So with respect to subsection F, the district did not raise that in their motion for summary judgment and wasn't raised by the petitioners in their cross motion for summary judgment. That said, Your Honor, my understanding is that subsection is meant to deal with votes illegally counted, and there's no contention that the actual vote count was in error.
And Mr. Tice, was that raised in the motion, or is that kind of, will that be, however we resolve this, will that kind of be hanging out there?
It was addressed, Your Honor. Our motion was to point out the proper way in which to present the challenge and how it doesn't succeed. And then we discarded the subsection F challenge. I don't know if that was in the motion itself, in the reply brief, and or in the resistance, but it's in there.
It was discussed somewhere.
It was fairly brief because that's what we thought it merited.
Yeah. So Mr. Tice, if, I want to talk to you a little bit about 62.5 sub 2 sub E, the requirement for the names for a subsection 2E challenge to illegal votes.
Yes.
If I were to find that misconduct requires something more than an innocent mistake or negligence, what's the purpose of providing those names in the statute, in your opinion? Why is that there?
Sure. That is there because as we read all of the cases from the Supreme Court, that type of a challenge is unique to every individual casting a vote. And so when you read through the case, that's what I was saying earlier, Your Honor, the court has a laser-like focus and spends lots and lots of time on each individual, where they resided, and a lot of the time it's so unique they're referring to intent, where the person intended to be, and then why they voted in the voting place that they voted in. So if we're gonna bring a challenge like that, that's why the legislature has codified that requirement to say, we're gonna need to know each and every individual, because these court rulings that we're reading, they have these people in and they're testifying. and they're explaining what they did, and they get so detailed as to find out where they were on particular days. That's why we need the names, which we don't have here.
And as a practical matter, how would a petitioner get those names in a situation like this?
Yeah, so the statute applies to people that either illegally voted or people that were prevented from voting. So how does it practically happen? It's poll watchers, people that are at the precinct and able to then testify, hey, this person was turned away, or this person who I know not to be a voter in this precinct was allowed to submit a vote. Your Honor, there's actually some of these cases, for instance, the one that petitioners rely upon, I believe it was out of Forest City, it was the Waldorf college students. They were all submitting their declarations to indicate that they were capable of voting in that venue because they believed themselves to reside there. But they provided all the other information about where they would go on breaks and where their family homes were. That was a case where they went into that to explain, what do we do here? Do we start with their declaration and then do we go further and figure out what's behind it?
Okay. Any reply, Mr. Tice?
If I may, Your Honor.
Yes.
Yes. Counsel argued and it was at the early part of her presentation that this election challenge does not neatly fit into any grounds. I have that down as a quotation there. We would respectfully disagree with that. It does very clearly and easily and neatly fit into one particular ground. The problem is we have two that are being presented to the court here, setting aside subsection F, and the petitioners here are trying to squeeze a round peg through a square hole. They're trying to rely upon that subsection E, illegal votes, to make their challenge, and admittedly, that is not a neat and clean ground to bring this challenge, because petitioners have to do some gymnastics to get past that requirement of a statement with the names and the precincts where the people should have been. So rather than go through the neat and clean path, which is what the district has submitted, the petitioners are going through a path that clearly doesn't apply, and they're going so far as to say this statutory requirement is not necessary, without any supportive case law, but simply argument. Now, what is neat and clean? Neat and clean is we have a statute that says if there's misconduct, fraud, or corruption, you can have a challenge, all right? And the point, of course, is what Counsel was referring to earlier under Chapter 39A1, the Election Misconduct and Penalties Act. The purpose of this chapter is to identify actions which threaten the integrity of the election process, and then goes on to say, and to impose significant sanctions upon persons who intentionally commit those acts. Well, yes, Chapter 39A is concerned about the integrity of the election process. So are all the other sections. Section 57, Section 62. There's no statute there that's going to say we're not concerned about something like that. We, of course, are. And that's why the legislature has this 57.1A2, which says if there's misconduct, fraud, or corruption, we're concerned now. It doesn't matter if that misconduct was intentional or accidental. Even if it's accidental, it could still be a concern. This case is a good example of that. If all ballots are willy-nilly thrown about, that would be a concern even if it was on accident. So the legislature, when they have that term misconduct, we believe it clearly includes intentional or unintentional. There's no reason why the legislature would say, we're not going to be concerned about integrity when it's on accident. Well, of course it still is. Why petitioners don't want to acknowledge that that could apply here is because of what follows, 57.4, that says, as the legislature pronounces that, yes, we are concerned about election integrity, we also know that if we apply this kind of a standard to set aside all elections whenever there's any kind of irregularity, we're going to be litigating these all the time. So the legislature has made a decision that if we set aside a particular precinct and it doesn't change the overall result, there's not an election challenge there. It's not going to be viable. That is a decision made by the legislature. That's a clean and neat way to challenge here. And it's so clean and neat that we have 39A4 that specifically reads it out to us and says a person commits the crime of election misconduct in the third degree if the person willfully commits any of the following acts: actions by an election official, furnishing a voter with a ballot other than the proper ballot to be used at the election. That section is reading out exactly what the court is confronted with here today. It's hard to get more neat and clean than that. We have this particular act here, and they say that's misconduct. It's just then using that same word in 57.1 and 57.4. It's not a leap, Your Honor. It's all election law, and it's just in one section saying, we're gonna get so detailed to tell you your particular circumstance is misconduct, and the other one says, here's what we do with it now. We're gonna look at it, we're gonna evaluate it, and here, it's undisputed that this public measure passes with or without that Ainsworth precinct. It makes no difference to the results, and the legislature has told us what the court needs to do here. Thank you, Your Honor.
Anything else, Mr.
Your Honor, my only response is that with respect to the election law that the district keeps referring to, subsection 4 refers to giving out a ballot that's not a proper ballot, and technically the ballot was a proper ballot, it was just given to the wrong voters. They didn't give another proper ballot that should have been gone, and that section again needs to be read in conjunction with the next or the next subsection. So that's 39A.4, I think 39A.5 is the next lower offense. It's the simple misdemeanor offenses, and it makes it a crime to manipulate or copyright a ballot. So while the district claims that this case squarely fits into subsection 4, that's not the case. This is not an instance in which there's an intentional wrongful act of providing an improper ballot to the voters. So I would ask the court, in reviewing these arguments, to read 39A.4 in conjunction with the rest of the statute.
Okay, thank you. I'm going to take the matter under advisement. It's a very interesting issue. Lots of new laws, old laws, case law from ancient times to parse through. I'll do my best, and I expect I'll get a ruling out. I'd like to say in a couple of weeks, maybe closer to 30 days, because there's a lot here. I appreciate you coming down and presenting the facts very well in the pleadings and the motions. So thank you, and we're off the record.
Your Honor, if I may.
Yeah.
I understand that you have an awful lot on your plate, no doubt, but there is some time sensitivity to this because we're talking about a construction project and prices are only going to go up for a long time.
Yeah, I guess, do you have any timeframes in mind, or is it just as soon as possible?
I would say it's as soon as possible,
Okay.
Understanding what you've got going
That's fine.
on.
I'll move it to the top of the list. That's a good point. And yeah, time flows on, and
So do prices.
yep, they're going in one direction. Okay,
Thank
I'll
you, Judge.
do my best.
Thank you.
I'll tell you, the temperature was hot in that courtroom. It was very stuffy, to say the least. You've watched it. How do you think it's going to go? Put something down in the comments to tell me and the other viewers what you think. And thank you for watching. Make sure to give this episode a like and follow and subscribe. It's free. Thank you to my sponsors, Greiner Auto Body, Car Doctor, McDonald Boneyard, Your Choice Family Restaurant, Girling Repair, B&B Propane and the family of Jet Stops, The Dutch Market, and Coffee Talk. I'm your host, John Bain. Stay friendly, Southeast Iowa.